The concept of judicial activism is incredibly controversial in the legal world. Before delving into the definition and controversy surrounding the concept, it is important to briefly describe the separation of powers. The separation of powers doctrine is established by Australia's Constitution and essentially separates the governance of Australia into three separate groups, being the legislature, who make the law, the executive, who put the law and policy into action, and the judiciary, who are tasked with interpreting and making judgments about the law. When we consider the concept of judicial activism, we are looking at that third branch, the judiciary. According to the separation of powers, the judiciary are tasked with interpreting and making declarations regarding what the law is, applying that to different factual scenarios, and going no further, so as not to breach the demarcation between the three branches. However, judicial activism exists in that grey area, whereby judges are perceived as exceeding their constitutional power. While there are various definitions of judicial activism, the concept ultimately boils down to the concept of a judge essentially reforming and overruling aspects of the law themselves, on the basis of their own opinions and perceptions of law, policy, and justice, which, from a separation of powers perspective, is the role of the legislature. There are varying degrees of judicial activism. Judges obviously have the power to interpret law and alter precedent according to the rules of that doctrine, which plays an important role in developing law and achieving justice according to the values of society at the time. However, what about the situation whereby the judiciary significantly changes the state of play of the law or the operation of the Constitution based on their own beliefs and values? It has been argued that a key example of judicial activism in practice is the famous Mabo decision, whereby Australia's High Court ultimately changed the law in Australia by recognising native title, thus creating a new form of proprietary right that had not formerly existed. Whilst this case obviously had a significant positive impact from a social justice perspective, and the legislature enacted this property right into legislation following this decision by way of the Native Title Act 1993, which gave legislative effect to this land right, this is a key example of the judiciary going beyond their interpretive role and acting in a way which critics deem as activism. Defenders of the concept of judicial activism refer to the concept as judicial creativity, with arguments arising that approaching judging in this way allows for increased judicial discretion and ultimately greater flexibility in our common law system. However, overall, the concept of judicial activism is incredibly controversial, and there is a fine line between the role of the judiciary in declaring and interpreting the law in ways that progress society and justice as a whole, and judges using their position to ultimately import their own beliefs and values into the law.